Thank you, gentlemen.
Thank you, Your Honor.
Thank you. All right, we'll call our final case for this morning, Arturo Hernandez and Sandra Hernandez. Morning, counsel.
Good morning.
Would you like to reserve some time?
Yes, I would like to reserve 5 minutes.
And if you could just keep your voice up for my old ears.
Yes, sir.
Thank you.
May it please the court, my name is Kelly Ruth. I'm with the Carlisle Appellate Law Firm, and I represent Arturo Hernandez, the former husband. This is an appeal of a final judgment of dissolution of marriage that awards the former wife with support payments totaling about 80% of the former husband's income. In addition to the marital debt, the former husband is required to pay over 100% of his net monthly income under the final judgment. He's appealing this excessive award as well as the requirement...
Well, that won't happen once the house is sold. Once the house is sold, that he won't have to make the payments, and then he won't be paying more than 100%, will he?
Correct, Your Honor. That is the case. But under the final judgment, other than the house being sold, there's no time limit, so arguably he could indefinitely be responsible for mortgage payments.
Does that problem get resolved? The final judgment entered here didn't address the question of whether the husband gets any credits for the amounts that he pays while they're waiting to sell the house.
Correct, Your Honor.
And I get the impression that the wife doesn't have the resources to make the monthly payment. Does that problem get resolved, at least as relates to the house, if the court were to require him to pay the mortgage but then gives him a credit when the house gets sold?
It would in part resolve one of our issues, yes. However, we are appealing the award of the mortgage payment in its entirety because of the excessive award when combined with the alimony and the child support and the debt as well.
But if she doesn't have the money, and so your problem is, I guess, on the house anyway, it's twofold. A, he didn't get a credit. B, when you factor that number in with the other numbers, he's paying too much.
Yes, and it's actually threefold. It also does not hold the former wife liable for a deficiency if the home is sold at a loss, which in this economy, that's a likelihood. So yes, Your Honor, the Florida law is clear, and the law of this court is clear, that a financial award that's excessive, that's compared to the spouse's ability to pay, is an abuse of discretion by the trial court and should be reversed. I think the simple math of this case is clear. When you take the rehabilitative alimony amount, the child support amount, the marital debt, and the mortgage payment together, it is in excess of the former husband's net monthly income, and his ability to pay should have been considered by the trial court in making this financial obligation. We already touched on it Your Honor, about the mortgage payments. We do object to that and request a reversal of the mortgage payment, but also at the very least ask that the court remand for the trial court to...
Well, did he agree to pay the mortgage payments until the house was sold?
I don't believe he did. Regardless, he did raise that issue in the motion for rehearing, disputing his ability to pay the mortgage payment.
Well, I don't know about, there may be a difference between agreeing to pay it and then coming back and saying later, well, I don't have the ability. Did he agree to pay the mortgage payments, and
I believe,
or was that a disputed issue between the parties? Because it didn't seem like there was much of a dispute between the parties as to anything when this...
Correct. I don't think he disputed the fact that the wife had no income and really couldn't pay for anything. He wanted to help her as much as he could. I think that's what the record reflects.
Well, did he agree to make the mortgage payments or not?
I believe he understood he had to. I think that's what the record reflects.
Well, I mean, there's a difference between understanding I have to and an agreeing to it. You're saying he didn't agree to it?
I don't believe, Your Honor.
Okay.
I think his position the entire time was he did not have the funds to support her, and he was not opposed to her returning to Colombia for that reason. The next argument I'd like to address is the trial court's error in awarding rehabilitative alimony. This was in error for several reasons. First of all, because it wasn't supported by competent substantial evidence. The former wife seeking alimony had the burden to show a valid rehabilitative plan. She had to show the goals of her plan, the amount of time that it would take in order to secure employment and income that was an appropriate level, how she could redevelop her previous skills or acquire new skills, the cost of the education, and the like.
Well, there was some testimony that she wanted to go to Florida A&M Law School, although admittedly she hadn't taken the LSATs, and said that her English was insufficient to allow her to do so. Would it be reasonable for the trial court to say, all right, I'm going to award you rehab alimony for a year to allow you to improve your English skills, and if you get into Florida A&M, then we'll continue it. However, if you don't get into law school, then the deal is off. I mean, could the court make sort of a contingent award, since her plan was improve my English and go to law school? If she improved her English but couldn't get into law school or had a change of heart or whatever, law didn't pan out for her, could the court make an award that was contingent upon her going to law school?
Certainly the court could have done that, but I think in this case there was not evidence to show she intended to go to law school. I believe the court is referring to statements made by the former wife's attorney, and these were unsworn statements. I don't think they constitute evidence and should not have been considered.
Wasn't the procedure of the trial somewhat unusual?
It was, Your Honor.
I've actually seen other transcripts that seem that's kind of the way this particular judge does it, but it makes it difficult for a record on appeal. I mean, it's kind of like if there's, well, do you agree to this? Do you agree to that? And if there's some dispute, there's kind of testimony. Well, I guess so. It just was odd the way it went.
Absolutely, it was, Your Honor, and I believe that any information about the wife's intent to go to law school was solely statements from her attorney.
Yeah.
To the extent the wife herself testified, she actually indicated she was not trying to take the steps to become self-supporting. She gave excuses for why she had not done so, why she did not attend the LSAT classes the former husband paid for. She gave excuses about her English not being good enough and she needed a year to take the LSAT. But certainly, Your Honor, if at the very least it should be remanded so that there are contingencies included in the final judgment. The way it reads now, she is entitled to this rehabilitative alimony regardless of whether she takes the LSAT, passes, or applies to law school, attends
Your
law school.
client's plan for her was to go back to Columbia and be a prosecutor, right?
That would be his goal, yes, because he couldn't support her.
That's what he suggested.
Yes, yes, and I believe the trial court thought the former husband was opposed to her returning. That wasn't the case. Another problem with the rehabilitative alimony award is that it impermissibly automatically increases at a future date, and this is prohibited by the law of this court under the Davis versus Davis case. For that reason, it was also in error.
I thought that, at least as to that part, if the rehab alimony plan is to be upheld at all, he seemed to approve that. He said, I'd rather pay a little less up front and more when she's in school and stretch it out.
Perhaps, Your Honor, but
it seemed like he was suggesting that the total amount didn't get changed, but it got stretched out over 4 years. I think the trial judge's inclination, the way I read it, was, I think, to give her $2,200 a year for a month for 3 years. And I think, she end up giving her $1,100 a month for a year, then $2,200 for 2, and then $1,100 for a year?
Yes, I think.
So the total number didn't change. But
Correct.
I'm not sure that our case law, assuming that there was a legitimate agreement to that effect, would necessarily prohibit that. The parties can almost agree to whatever they want.
Correct. I don't think it was clear that there was an agreement. I think he was wanting, obviously, to pay the lesser sum as opposed to the greater sum. But I think the case law is clear that the proper procedure in that circumstance would be to come before the trial court again and look at the evidence at that time and then increase the alimony if the facts show that that's required. The third problem with a rehabilitative alimony is that the trial court did not include the requisite factual findings required under Florida Statute 61.08 subsection 2. Under that statute, the trial court is required in all dissolution actions to include findings of fact regarding specific factors. The standard of living, the duration of the marriage, the age and physical, emotional condition of the parties, the financial resources of the parties, the time necessary to acquire the sufficient education or training to be self-supporting and get appropriate employment, the contribution of the parties to the marriage, and the sources of income available to the parties. And it's undisputed law of this court that the trial court's failure to include these facts finding in the final judgment support reversal of a rehabilitative alimony award. In this final judgment, it does not mention Statute 61.08 or include the statutorily required findings at all. The former wife fails to address this.
Was there ever any objection that was lodged with the trial judge about the way this proceeding took place, more like a mediation-style proceeding than a trial? Did anybody ever object to that?
Not at the trial level, Your Honor, but I believe the former husband did raise it in his motion for rehearing. So because the trial court failed to include the 61.08 fact findings, we request reversal of the rehabilitative alimony award. Finally, Your Honor, I'd like to address the argument that the final judgment was not supported by competent substantial evidence. We already touched on this a little bit, that the proceedings took place in a very informal manner. I think it's undisputed law that an attorney's unsworn representations cannot be considered as evidence. And the majority of what was said to the trial court were statements by the former wife's attorney and an informal dialogue between the court and the former wife's attorney. The former wife doesn't cite to any evidence in her brief that constitutes evidence. Again, it's just representations by counsel. She does cite to a financial affidavit, but under that affidavit, the simple math of the case, again, shows that substantial competent evidence does not support the financial award.
You would agree that he did at least agree that she was entitled to rehabilitative alimony. You would at least agree with that. He did agree to that, didn't he?
I don't know, Your Honor. I believe he knew he needed to help her get back on her feet somehow. I don't know if he explicitly stated, yes, she's entitled to rehabilitative alimony.
The issue is his ability to pay and how much and for how long, right?
Correct. And he was not opposed to her returning to Colombia, where she could, in fact, work. And I think the trial court the entire time proceeded under the assumption that he was opposed to her returning to Colombia. So, Your Honors, unless you have additional questions, I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel. Morning, sir.
Good morning, Your Honors. May it please the Court, I'm Michael Jones. I'm with the Wheelock Law Firm from Orlando, Florida. I have the honor and pleasure of representing the appellee here, Ms. Hernandez, the former wife below. Let me just jump in by starting by I believe that I heard counsel for appellant state that the former husband at trial was not opposed to the wife returning to Colombia, and I don't believe that that is an incorrect statement of the record on appeal and the record of the trial, Your Honor. The situation at trial was that the court inquired, are you going back to Colombia? The wife directly and through counsel stated, no, I'm not going to. The husband's counsel then on page 47 of the transcript said, well, for the trade-off of my client being able to have his son here and for the benefit of his son growing up in this country, I think we'd be possibly willing to work out some concessions at this point in time. The court talks about going to law school. The attorney says yes, so at this point we're willing to help her out. So I think he very definitely stipulated that this would be an appropriate case for rehabilitative alimony.
Was there ever any evidence or testimony presented about his ability to pay the amounts in the time periods that were ordered here?
Yes, Your Honor, there was. There was his financial affidavit which stated his income, which showed, and let me make sure I get the number exactly correct, that he had a net income of about $9,800 per month, and that the combined child support and alimony payment therefore constituted 38%.
Well, he expressed concern about his ability to pay all of this money to the trial court, didn't he?
Oh, absolutely. You know, he was saying, I have credit card debt, I have mortgage debt. He absolutely said that. He also said, I am behind on the mortgage. I believe there's a reference in the transcript that he was a month behind in the mortgage payment. I think it's very clear that it was ordered that the house be listed immediately for sale. I think the court said.
Do you agree that he should not be given credit for those mortgage payments in the event this house is ever sold?
Your Honor, I think under the circumstances of this situation that the court appropriately did not consider credits. I do not believe that the court was asked to consider credits. When you look at the credit situation, if I may, that seems to be more in the long-term situations. Okay, we've got a 9-year-old child. The parties can afford to.
Well, shouldn't it be expressed in the order whether or not he gets credit? I mean, it seems to me like if he's going to make the mortgage payments and the house is sold, and he's making the mortgage payments to keep the house until it's sold, it seems to me like he should at least get credit for that.
Well, first of all, there's the question by his own admission that he was at least a month behind. Counsel wants, and the former husband in his brief and through his arguments wants to argue that there should be some determination of credits, there should be some determination of deficiency. To a certain degree, that's almost speculative. If the house is sold for less than what it's worth, by definition, it's going to be a short sale that the mortgage company is going to have to approve and take that. There's not even going to be a deficiency on a reference in the brief.
Not necessarily. It could be a foreclosure.
Mm-hmm.
It could be a foreclosure, and in that situation, the parties would be where they would be.
What percentage of his income, if you take his rehab, child support, and the mortgage payment, what percentage of his net is consumed?
Your Honor, he was the source of income for all of these payments when it was an intact marriage.
I understand. My question is, what percentage is consumed?
He absolutely was paying his income to pay for the household, to pay for the child.
So the answer is 100%?
Oh, absolutely.
So what is he supposed
the numbers
to live
are the
on?
numbers, Judge.
I guess my only question is, assuming no other problems, what's he supposed to live on while all this is going on?
Well, Your Honor, the fact of the matter is that he may have to go to the mortgage company and make accommodations. He may have to have the house sold quickly. These are all speculative type of arguments. He can come back to the court on any number of theories. Counsel saying, well, what if she doesn't do the rehab plan?
Seems a lot less speculative. Well, let's see. We know for sure he's got the mortgage payment. We don't know for sure that she's going to law school. I mean, the rehab plan seems a whole lot more speculative than the requirement to pay the mortgage.
I'm glad you asked that. I'd like to address that, of whether the rehab plan is speculative. What the trial court does is take a snapshot, and at the time of the trial, this was a plan, this was proposed, there was evidence to present it, the husband stipulated through his counsel that this was a rehab case. If down the road, and the case law is very clear about that, we enter a final judgment, there's $1 a month in rehabilitative alimony.
He never stipulated to the amount, did he?
Excuse me?
He never stipulated to the amount, did he?
No, he didn't. And when you go down the road, and then the rehab plan is you're going to go back to law school, and you don't go back to law school, you can move to cancel or terminate or modify the rehabilitative plan. But that's all speculative, and that's all modification type of issues. So I think that we have a situation here, and there's been some question about the trial procedure that was used by the trial court below. Appellant initially started in his initial brief to say that the
was this really even a trial?
Yes, Your Honor, I believe it is. And the reason
evidence and testimony was witnesses testified and
Your
examination
Honor,
and cross-examination and all that?
All of that happened or was attempted to happen, and there was absolutely no objection at any time during the trial proceeding to the trial proceeding in the way that it did.
How do this is not the first case that I've seen that this kind of procedure went on with this particular trial. But how can you object to it? I mean, what are you going to say? I think, it's unfortunate, but I think she kind of is heavy-handed on how she does that. I mean, lawyers are kind of faced with, well, I guess this is what we're going to do. It's kind of agree, and then if there's some fact dispute about something, then you kind of take some testimony. I mean, it is pretty unusual.
Respectfully, Judge, I disagree, and I don't think the court either here in the 5th District or in any of the Florida courts has ruled that this proceeding cannot be done, and I don't think we have to reach that. I think we have to look at whether
Maybe
in
seeing
the
a couple
circumstances...
cases here coming up that may say that.
The problem with it is that it makes it difficult for an appellate court to review it because where's the substantial competent, where's the evidence that supports any findings that the trial judge may make? I mean, unless there's clear, specific agreements as to what they're going to pay, when they're going to pay it, and for what they're paying, and whether they're going to get credit and all, and that didn't take place here. So we have some indication that there may be some agreement on some things and not others. And when you have a proceeding like this, and there's really a lack of competent evidence that's introduced at the trial court that the trial court can rely on to make factual findings to include in the judgment, that makes it very difficult for us to review. And that's why proceedings like this, unless the parties actually hammer out specific agreements and stipulate to it, makes it difficult for appellate review and makes these proceedings suspect.
Your Honor, respectfully, I believe in the totality of the circumstances of this particular trial, and I can't mind read whether there's going to be new case law or not, but at this point, as the case law exists...
Let me just say, in the other case I looked at, our lawyer made the same argument that you're making.
Well, I hope I do as well, or if not better than...
It's just hard, as Judge Sawaya said, it's just almost impossible to figure out, what the evidence was.
Well, Your Honor, I respectfully, and I understand the question, and I've heard it from both of the two judges, but respectfully, I don't think that's the situation in this case. I can't speak to a broad brush or whether the courts at this court or some other court is ultimately going to say, no, you can't do this. This was not...
I don't know that. I mean, I think that there's a lot of utility to a trial court trying to see if the parties have an agreement. And if they have an agreement, what the trial court should do is say, okay, let's hear your part of the agreement, your part. Do you agree? What do you agree on? And get it all specifically laid out. Mm-hmm. And then the issues that they can agree on, then you have your testimony and your evidence presented so the trial court can make the findings. But it seems like this was something even a little bit different than that.
Judge, again, and respectfully,
You think the record supports...
I think the record supports that. And let me address that and put on this argument in this record why I believe that. This is not the case law kind of situation where the judge says, I got 10 minutes, you're going to do it in 10 minutes. The judge listened to everything that had to be done. This was a proceeding that was not truncated. It lasted almost 2 hours. The record shows it lasted, I believe, 1 hour and 45 minutes. The parties were, in fact, sworn. The parties were always permitted to say whatever they had to say. They were both represented by counsel. The husband, on at least several occasions, and for example, I'll point to the trial transcript, page 38, said, Judge, I want to say something. The judge went, yes, say it. And the husband was fully heard and said that. I believe that trial counsel all the time, Judge, object to what a trial court does. I don't think that any trial judge I've ever dealt with in almost 30 years has objected to the fact that I object. They very well may overrule me and move on counsel, but if there is something that I as a trial attorney do not particularly like, I do not like an evidentiary ruling, I don't like evidence that's being admitted, it's incumbent upon me to object. If I don't object, I've waived it. If hearsay comes in or is being testified to and I don't object, that hearsay is going to be in the record. If the judge is asking questions back and forth to sworn witnesses using sworn financial affidavits, having that evidence before her, and nobody stands up and says, Judge, I've got some questions I need to ask my client or I need to cross-examine on that point, that's on the trial attorney. And if they don't do that, they've waived that. This was a long proceeding, and the court at the very end went to both sides and said, do you have anything else that you want? Do you have anything else that you want? That's on the record, I believe, on page 91 of the trial transcript. Everybody said no. So in this case, in this proceeding, this judge afforded these parties full due process, full opportunity, had sworn testimony. Maybe it wasn't in the 1 hour of, is this your financial affidavit? Yes, it is. Is this the amount that you pay for groceries? Yes, it is. Is this the amount? It may not have been that type of evidence, but the same evidence that would be in that was there. The court went over the financial affidavit, made findings of fact. Yes, that's a reasonable amount. No, that's not a reasonable amount. Oh, the car payment. In fact, there was a discussion. Initially, the former counsel at trial was saying that the car payment was $600, but it turned out that was both car payments. And so the court did the inquiry necessary to sort out the facts and to have a record for this court to review in this case. And I don't think the court in this case needs to reach a determination as to whether, as a general rule, what exactly we allow our trial judges to do. And the case law would suggest that the trial judges have a great deal of latitude. It's only when the trial judge is doing something where a person is saying, I have more evidence, or I need to present this, or I need more time, and the trial judge does not permit that. That's when that becomes an impermissible trial procedure. The alimony, if I may briefly address, Your Honors, was founded. There was a 3-year payment. There was some accommodation done in a couple of reasons by taking part of the first year's payment and making it paid on the fourth year. That was not an automatic increase in the payment on a future event. It frankly gave the former husband a break because of the mortgage payment for a while. It recognized that there would be less costs to be a little more competent in English and take the LSAT as opposed to paying law school tuition at Florida A&M University. So it was a reasonable rehabilitative alimony plan supported by the evidence I've talked about, the mortgage payments. The rehabilitation plan certainly can be oral. It wasn't an impermissible change of events. And again, if I may also point out, there's numerous occasions, and there's at least a dozen times in my record, and I can run by the page sites for you, of when the husband actually did testify. He was afforded a full hearing, a full opportunity. Unless the court has any further questions, I'll rest on my argument made today and the briefs made today, and respectfully request this court to affirm what happened in the trial court below. Thank you, Your Honor.
Counsel.
Your Honors, I don't want you to get bogged down with the former husband's failure to object, or we're not disputing that the trial court has the discretion to run the proceeding as he would like. That doesn't change the fact that a final judgment has to be supported by competent substantial evidence. And if you take apart what was shown to the court, the former wife's attorney here does not dispute the applicability of the Sloan versus Sloan case or Arnold versus Arnold, where unsworn statements simply cannot be considered as evidence. If you look at what the parties stated, and yes, they did speak to the court, and that can be considered evidence, those statements are few and far in between. It was about, for example, the former husband's present living situation. They discussed the properties in Colombia, just facts that aren't really relevant to the issues on appeal and don't provide the competent substantial evidence necessary to uphold the financial award and these other things. Same thing with the alimony. There's no competent substantial evidence to show that she was on a path to be rehabilitated, that she intended to do those things. To the contrary, the few statements she made shows excuses why she was not ready. I would like to address opposing counsel's statement that the record does not support that the former husband was not opposed to the wife's return to Colombia. I have a record cite from the October 31st proceeding. It's T134, and the June 16th proceeding, T2 23 to 24. I believe those support our position that he was not opposed to her return, and I think the trial court was aware of that. I would like to talk about the financial affidavits. There's a little bit of a confusion in the record about which one was filed. I believe there were several that were executed at the same time. Taking opposing counsel's figures, he quoted approximately $98,000 a month net monthly income of the former husband. If that is the case, and if the trial court did rely on that particular financial affidavit, that amount is actually a gross monthly income from the financial affidavit. And in all the case law cited in my brief, the proper analysis is to look at the spouse's net monthly income, because obviously that's the disposable income. So if in fact the trial court did rely on that $98,000 a month figure, that was improper as well.
I thought the financial affidavit was, and I forget, I thought it was either $150,000 or $180,000 a year gross.
Correct. I don't think the affidavit stated $180,000 a year, but one of the figures was approximately $15,000 per month. So if you multiply that by 12, you would get $180,000. Right. So again, that's a guess. We don't know where the court got the figures from, but that is a gross income, correct? And opposing counsel has stated that the 38%, that's only counting the alimony and the support award. That's totally disregarding the marital debt and the mortgage payments. And obviously he can't live once he has paid all that out. It is in excess of 100% of his net monthly income. The other point I'd like to make, Your Honors, is the whole issue regarding the credit. I don't believe the opposing side has rebutted the applicable law that prohibits one spouse in a dissolution action from increasing the equity of another spouse. So regardless of what happens if this home eventually sells for profit or at a loss, regardless, the parties as tenants in common have to remain equal. So at the very least, the final judgment needs to provide for credit or hold the former wife liable for a deficiency. And we, of course, are requesting a reversal of the entire payment of the mortgage, but at the very least, yes, it should include a credit, because under the applicable law, they should remain equal upon dissolution of marriage. If Your Honors have no questions, I'd like to just rest on my briefs.
Thank you very much.
Thank you.
Thank you.
Good job.
Thank you both. Thank you. Have a good day. That will conclude our session for the morning.